Hello and welcome to Trusts and Estates Weekly. I'm your host, Kevin Bemmel, and we're here at 10 o'clock every Monday morning, 10 o'clock Pacific time, that is. And we talk about all things related to estate planning, probate, trusts, whether they're living trusts, special needs trusts, all those kind of things, both from your own planning perspective and from that of professionals who help clients engage in this process and see it through to its conclusion. So today, I wanted to spend just a few minutes talking about an issue. I recently had a meeting with a fellow named Josh Yeager, who basically works on administrating trusts up in my sort of hometown, Santa Barbara, California. That's where I was raised, although I wasn't born there. And we were talking about how lengthy a process and how costly a process it is oftentimes to administrate an estate or to administrate a trust. And I think one of the key issues behind that is that every state basically has its own set of rules with regard to handling probate and estate matters. So for those of you who are not familiar with what's called federalism, so in the United States, we have the federal government, the government in Washington, and the laws that it passes apply to all 50 states in the country, as well as territories such as Puerto Rico and Guam, U.S. Virgin Islands, etc. And the federal government is constrained by the Constitution in what areas it governs. So, for example, when it comes to national defense, that is a federal government responsibility. That's why we have one Army, one Marine Corps, one Navy, one Air Force. Okay, those are the branches of the military, and they are run at the federal level. We do have what are called National Guards, which are essentially the modern day equivalent of state militias. And they are under the control of the governor of each state. However, during times of national emergency, they can be federalized, which means the president can call them into essentially what amounts to active duty as part of whichever component, whether they're Army National Guard or Air National Guard, they would go to the Army or the Air Force, respectively. There is no Marine Corps or Navy National Guard. And so those are laws at the federal level. With the exception of tax laws that apply at the national level to probates and estates, nothing else really at the federal level affects how trusts and estates operate. Those happen at the state level. So the U.S. Constitution basically says that the federal government can only involve itself in those powers specifically articulated in the U.S. Constitution. Every other power is left to the states or to the people. And since the federal Constitution does not allow the federal government to control trusts and estates, that's left, again, to the states or the people. In this case, each of the 50 states has its own laws. Now, that can be good, but it can also cause some difficulties. So it's good in the sense that each state can craft laws relevant to its particular population, its size, the complexity of the issues within those states. Where it becomes more problematic is a situation where somebody owns property in more than one state, and now you have multiple jurisdictions that apply. And so all of that complicates the process of settling an estate, handling all the various issues. Add on top of that, each financial institution has its own way of dealing with trust and estate matters. So TD Ameritrade, which actually merged with, I think, Charles Schwab, if I'm not mistaken. So they have their way of dealing with trust and estate issues, and those are different than some other brokerage like Merrill Lynch or UBS or whatever. So if an estate holds accounts from multiple financial institutions, each one of those has its own way of handling that matter. So you don't just fill out sort of, one form that all of them use. What you do is you have to go through the process for each one of those financial institutions. And so again, that further complicates things. Even for an estate that has property only in one state, okay, it's not at all unusual for an estate to hold accounts at more than one financial institution, okay, especially if it's of any size, and the owner of the property prior to death wanted to make sure that their funds were covered by FDIC insurance. So oftentimes, in order to do that, they will break up their deposits so that the amount they have in any one bank or financial institution is within the insurance limits. I believe it's $250,000 per institution. So if you've got $400,000 in one institution, let's say it's at Bank of America, only $250,000 of that is insured by the FDIC. The rest of it, if Bank of America were to fail, God forbid, right, then that money would be either lost or it would be put in line behind all the other creditors for Bank of America. On the other hand, if you had $400,000 and you put $200,000 of it at Bank of America and the other $200,000 into U.S. Bank, okay, so those are two separate institutions. You're covered up to $250,000 a piece, and so now the entire $400,000 is covered, and that's great. You want that. However, when it comes time to settle your estate, there's going to be two separate processes: the Bank of America process and the U.S. Bank process. Okay, now that's probably a small price to pay in order to make sure that your funds are fully covered, especially earlier this year we had several bank failures, like Silicon Valley Bank, First Republic, and there was one other if memory serves, right? So now, in those cases, the depositors didn't lose any money. The federal government stepped in to make sure that didn't happen, but that won't always be the case, okay? And so these are the kinds of decisions we need to make when we're putting together our estate plan, and they're the kinds of issues that the person or people charged with settling our estate are going to deal with after we are gone. And so, again, these all make dealing with estates more difficult, more time-consuming, and more costly. So I'm going to go ahead and share my screen. And yes, here it is. Okay, so quite a number of years ago, the Uniform Law Commission put together a uniform trust code. Okay, now this is not the only uniform law that exists. There's something called the uniform, for example, there's something called the Uniform Commercial Code, okay, the UCC. Now, prior to the UCC, when a lender wanted to lend money on personal property, that is property that can be moved, such as um, machinery and equipment. So let's say, for example, you had a company that built roads, and you had big earth moving tractors and those kind of things. Okay. So before the UCC, it was difficult to, number one, determine who was in fact the true owner of that equipment, but more importantly, whether that equipment had previously been used as security for a debt. So with the creation of the Uniform Commercial Code and a document known as Form UCC-1 was created, and eventually all 50 states adopt the Uniform Commercial Code and the use of this Form UCC-1. And so now lenders can look for a filing by a particular company or individual for that matter, to see what of their personal property has been used for security for a loan. Okay, so if those big earth-moving tractors have previously been used, or I shouldn't say have previously been used, are currently being used as collateral for a loan, a lender thinking about lending money on them can do a UCC-1 search for that company and find out whether there's a UCC-1 form on file showing that these big earth-moving tractors are indeed being used as collateral. So it gives greater protection to a prospective lender. Not only that, but because it's a universal practice now, so it's the same in all 50 states, okay? There may be some minor differences, but for all intents and purposes, the way personal property like that is used for collateral is now universal. Each state, though, has decided to do that on its own. It was not the federal government who told the states you must adopt the Uniform Commercial Code. It was each state deciding to do so. And so in the same way, the Uniform Trust Code is now going through that process. And if you see this map here, you see that although it's where any state that's in blue is a state that has already adopted the Uniform Trust Code. And you can see that it's quite a number of states. However, there are certain large, notable states that have not, including my home state, California, New York, where there's a lot of wealth, and Texas, which has become a much more populous and wealthy state over the years. Okay, so you will notice that Florida, which is the kind of the other big gainer as a result of COVID, has adopted the Uniform Trust Code. Okay, Alaska has not, but Hawaii has. Okay, so there's what, roughly, let's see, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15. It looks like there's 15 states that have not adopted the Uniform Trust Code yet, as well as the territories of Puerto Rico. I think this is the U.S. Virgin Islands. This is meant to be the U.S. Virgin Islands and Guam. Okay, now, if you look over here, enactment history, so you can see that which states have enacted it, and this is the version originally drafted in the year 2000. So if we'll go here, bill list. I think that's what we want. Let's see if this, yeah. Okay, so in actuality, and here you can see the year in which it was adopted by the various states that have adopted it, okay, and how many did. So, starting in 2002, one did, a whole bunch did in 2004 through 2006. And then it's kind of been ones and twos for the most part since then, okay? The most recent state to adopt it is Hawaii. Connecticut did in 2019. And what this does is it gives a relatively uniform set of rules for handling probates, trusts, and estates. You see this right here, okay? We'll look at the summary here. Okay, no, yeah, that isn't there. Okay, so what this does is it allows people who act as fiduciaries, basically, whether it's individuals like me, a professional fiduciary, or trust companies. Okay, they for basically 35 out of the 50 states, it gives them a relatively uniform set of rules that they have to follow. Okay, so let's close out of this and let me show you. Now, here we go. Okay, so here is the Uniform Trust Code. Okay, this is the actual document itself. This is a PDF for it. You see Uniform Trust Code. It was most recently annotated this year, 2023, okay, drafted by the National Conference of Commissioners on Uniform State Laws. And it's approved and recommended and enacted for all states, okay, even though not all states have adopted it, okay. And you can see it was originally promulgated in the year 2000 and amended 1, 2, 3, 4, 5, 6 times, and comments were recently updated in 2020 and most recently 2023. Hence, you can see April 2023 is the most recent version, and it's 182 pages long, so it is a lengthy document, okay. And you can see just a couple of things of kind of historical note. Okay, the National Conference of Commissioners on Uniform State Laws is in its 114th year. Okay, so it's been around since about what, 1909, I guess. 1909, yeah, that would be right. Okay, and it has practicing lawyers, judges, legislators, etc., and in state governments as well as the District of Columbia, Puerto Rico, and the U.S. Virgin Islands. So I guess it doesn't include Guam. Okay, and here's the committee, the original committee. Okay, and you can see here's the table of contents. Okay, and it talks about all the basics. There's general provisions. There's judicial proceedings. Okay, which is in other words, court proceedings. There's representation. Okay. And then there's, here we go, creation, validity, modification, and termination of a trust. Okay, so this is the whole part dealing with here. Here's creditors' claims, and then it goes on to revocable trusts. Okay, I've spoken about those in various previous shows. Office of the trustee, duties and powers of the trustee. Okay, in this case, that applies to a trust. Okay, the Uniform Prudent Investor Act. Okay, and this sets the standards for how trustees have to manage the assets in an estate, assuming that the state has adopted, right, the Uniform Trust Code. Okay, and here's the liability of trustees and rights of persons dealing with the trustees, typically the beneficiaries, although it could be the grantors as well. Okay, and then finally some miscellaneous provisions. Okay, so it gives you an idea of the scope, and just that alone you can see that there can be a lot of complexity in dealing with a probate or the settling of a trust or estate. Okay. And so imagine if there were 50 sets of rules, one for each state, plus Washington, D.C., Puerto Rico, and the U.S. Virgin Islands. That'd be 53 different sets of rules. Okay. And for a particularly large estate that maybe has property in 3, 4, 5 or more jurisdictions, right, that becomes a very, very complex situation to deal with. With the advent of the Uniform Trust Code, so the rules are much more uniform, and we can hope that eventually financial institutions will find it beneficial to perhaps create a uniform set of documents for dealing with trust and estate matters, such that perhaps there would be one form, like a uniform probate transfer form, or a uniform probate estate and trust transfer form that all of them will accept, right? And so we can fill out that form one time, and it can be used from 1 to 100 financial institutions. You can see how much time that could potentially save. Let's say it takes maybe between 15 and 30 minutes to fill out one of those forms. Okay. So if you have to only do it once, okay, let's say it takes 30 minutes to do it once, right? Well, that's a lot less time than filling out 4, which may take as little as an hour, but may take up to 2 hours. Okay. And oftentimes the cost to settle an estate is on an hourly basis. Okay. So if a professional fiduciary is charging $200 an hour, $300 an hour, or if there's a lawyer handling it at $400 or $500 or more an hour, you can see those costs add up very quickly. So the idea of simplifying the process could mean a tremendous savings for both in time and in money in dealing with a probate, or, like I said, the settling of a trust or an estate. So for those of us, and I'll go back to this one more time. So for those of us in states that haven't adopted the UTC, I presume the reason is because places like California and New York feel that the matters are so complex, they want to exercise additional oversight, and that's a shame. What would be better would be for these states that haven't adopted it to address their concerns to the Uniform Law Commission, what reservations they have about it. And maybe this is going on, by the way. I don't know. I haven't heard of the UTC being presented for adoption here in California. Maybe it's happening behind closed doors. But the better process would be to submit their objections or their concerns to the commission and work them out so that they can then adopt the Uniform Trust Code. Okay. And in that way, each state makes sure that their particular areas of concern are addressed, while at the same time serving the citizens of their state by making the process of dealing with probates, trusts, and estates as efficient and as low cost as possible. Okay. Now, as you might imagine, there can be powerful organizations who are opposed to making things less costly. Okay. And not to cast aspersions on lawyers, but I can imagine that there are lawyers out there who they make a lot of money out of handling trusts and estates. And by the way, same with trust companies and professional fiduciaries. And they may like the fact that it's complicated, and further complicated by the fact that it's different in many. You've got basically 15 states that haven't adopted it, plus, the other 35, 15 states and it looks like 2 territories that haven't adopted it. So you've got 17, and then you've got those that have. So you've got 18 different sets of rules to deal with. If at the most, well, that means a lot more money in settling an estate. Now, for people who make their money doing that, I suppose that's a good thing from their perspective. From my perspective, while of course I want to make a nice living, what I also want to do as a fiduciary is keep in mind that my obligation is to act for my client's interests above my own. So maintaining a system that keeps the cost to clients higher. The cost, again, I want to stress this, in terms of both time and money, higher, is not a system beneficial to my clients. Now, I'm emphasizing the cost in time, because if you're the beneficiary of an estate, it's not just the fact that it's costing the estate more to settle and get the assets in the hands of the beneficiary. It's also taking longer. And the fact that it's taking longer has an impact on the beneficiaries too, especially if they may have needs for the resources that they're inheriting, or it may just be the stress of having to deal with the unknown. How is this all going to work out? So those are costs as well. They're not direct financial costs necessarily, but they are emotional costs that beneficiaries bear. And so, again, from my perspective and from Josh's perspective too, we were the ones who were talking about this. I think there's, we're looking for ways to simplify the process, shorten the process, make the process less costly from a financial standpoint. And so, for those of you who are watching this and perhaps have the same concerns, and by the way, I met Josh through another colleague, Tim Borcher, who has a trust business based in, I believe it's Pennsylvania, but it could based in Massachusetts, I believe. And Tim has, again, the same concerns. We're sort of the three musketeers here, starting out to be, although I would rather be D'Artagnan, frankly, because he was played by Gene Kelly. But in any event, there are other people concerned about this same issue, and you may be among them. I invite you to get in touch with me, share your concerns on this, and your ideas for how we can deal with it, how we can simplify the process, make it faster, less costly, because it's to the good for everybody in the long run. And the fact of the matter is, here in California, we're facing a tremendous shortage in people who have the skills and knowledge and experience to be able to act in the position of fiduciaries and help people settle trusts. So, and because it gets more complex every year, it seems like, for someone who's never done it before, it's especially difficult. And the cost to them then of getting proper legal advice and the time it takes is particularly burdensome. And so because of that, it does behoove us to figure out how we can make the whole process more efficient in order to make sure that people in general are well served. So a bit of an opinion piece. I don't think this is political, frankly. I, for the most part, eschew politics, but really, looking at this from the standpoint of being a professional fiduciary, what's best for my clients, I think this issue should be discussed. How do we make this work better for grantors, for beneficiaries, for trustees, for financial institutions? How do we work together in the best interest of the people we serve? So that's what I have for you today. Some food for thought as we head into the end of the year. There's going to be holiday parties and get-togethers and all those kind of things. And here's a topic of discussion, I think, that's well worthwhile. Something that as we sip our eggnog, although I'm not an eggnog guy, but sip our cocktails and munch on our hors d'oeuvres, maybe we can wrestle with these things and perhaps some ideas will come. Certainly, if you do have ideas, please do share them with me. How to contact me will be in the show notes after this episode posts. And you can contact me by email or social media, etc. Would love to hear from you. And so coming up tomorrow at 10 a.m., this is our new time for business lessons from the military. Okay, we'll be continuing our discussion about intelligence. We're going to be talking about I lost what the topic is here. I'll look it up. See, because I have my list right here. Classes of intelligence. See, I had in my mind causes of intelligence, but it's classes of intelligence. So the different types of intelligence, basically, that are out there. We're going to talk about that tomorrow at 10 a.m. Pacific time. And then on Wednesday at 12:30 p.m. Pacific time, my guest is going to be Vaughn Marie Thomas. Now, you may remember Vaughn Marie from a few weeks ago here on Trusts and Estates Weekly. We talked about accounting issues specifically for trusts and estates. On Wednesday's show, People Making Money, Vaughn Marie is going to talk about her career, how she got into accounting, and she works primarily with small businesses and why she finds that particularly satisfying. I should say she works primarily with small businesses and trust and estate matters, not unlike myself, which is one of the reasons why Vaughn Marie and I have become friends. And so, for those of you, especially for those of you interested in perhaps pursuing a similar career, I invite you to join us on Wednesday. You can go to my Eventbrite page. You can always get a free ticket to join me live, any of my guests live, anytime you want, or you can, of course, always watch us on social media. So thanks for joining me this morning. Great kickoff to the week, I hope. It's nice to be back, and look forward to seeing you later in the week. Signing off, Marie, you are my belle. All the best, folks.